The Unconstitutionality of the Laws of Congress Prohibiting Private Mails by Lysander Spooner, published 1844. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Michelle Fry, Baton Rouge, Louisiana. To the public. The American Letter Mail Company present the following exposition on the grounds on which they assert their right to establish mails and post offices in competition with those of Congress. If the public are satisfied of the correctness of the principle, the company asks their patronage to enable them to sustain it. Argument. Of the following propositions, almost any one of them is sufficient, I apprehend, to prove the unconstitutionality of all laws prohibiting private mails. 1. The Constitution of the United States, Article 1, Section 8, declares that, quote, the Congress shall have power to establish post offices and post roads, end quote. These words contain the whole grant, and therefore express the extent of the authority granted to Congress. They define the power, and the power is limited by the definition. The power of Congress, then, is simply, quote, to establish post offices and post roads, end quote, of their own, not to interfere with those established by others. 2. The Constitution expresses neither in terms nor by necessary implication any prohibition upon the establishment of mails, post offices, and post roads by the states or individuals. 3. The Constitution expresses neither in terms nor by necessary implication any surrender on the part of the people of their own natural rights to establish mails, post offices, or post roads at pleasure. 4. The simple grant of an authority, whether to an individual or a government, to do a particular act, gives the grantee no authority to forbid others to do acts of the same kind. It gives him no authority at all relative to the acts of others, unless the acts of others would be incompatible or in conflict or collision with the act he is authorized to do. It does not authorize him to consider mere competition and rivalry as conflict, collision, or incompatibility. This doctrine fully admits that Congress, quote, have power to make all laws which shall be necessary and proper for carrying into execution their own power of establishing post offices and post roads, end quote. But then it asserts that every law they pass must, in order to be constitutional, be a direct, positive, affirmative step in actual execution of their own power. It must in some way contribute affirmatively to the establishment of their own mails. But the suppression of private mails is not an act at all in execution of the power to establish others. If Congress were to suppress all private mails, they would not thereby have done the first act in execution of the power given them by the Constitution to establish mails. The entire work executing their power of establishing mails would still remain to be done. This doctrine also fully admits the absolute authority of Congress over whatever mails they do establish. It admits their right to forbid any resistance being offered to their progress and to prohibit and punish depredations upon them. But it at the same time asserts that the power of Congress is confined exclusively to the establishment, management, transportation, and protection of their own mails. 5. It cannot be said to be necessary to prohibit competition in order to obtain funds for establishing the government mail, because Congress, in order to carry out this power, as well as others, are authorized, if necessary, quote, to lay and collect taxes, duties, imposts, and excises, end quote, and this is the only compulsory mode mentioned in the Constitution for providing for the support of any department of the government. They are under no more constitutional constraint to make the post office support itself than to make the Army, the Navy, the judiciary, or the executive support itself. Footnote. There is not even a proprietary in making the post office support itself, any more than in making any other department of the government support itself. An important portion of the expenses of the department are incurred for public objects, such as the transmission of official correspondence, the private correspondence of official men, and of tons and hundreds of tons of political documents. If the government are bound to provide for all these things, it should be done at the general charge, and not by the partial and unequal mode of levying double or triple charges upon the private correspondence of individuals. If Congress cannot carry the letters of individuals as cheaply as individuals would do it, there is no propriety in their carrying them at all. The correspondence of private individuals, which is now sent through the public mails, could probably on an average be sent through private mails for 1/3 of the present expense. The overplus demanded by the government is an extortion for which there is no justification. 6. The power given to Congress is simply, "to establish post offices and post roads," of their own, not to forbid similar establishments by the states or people. The power "to establish post offices and post roads" of their own, and the power to forbid competition are in their nature distinct powers, the former not at all implying the latter, any more than the power on the part of Congress to borrow money implies a power to forbid the people and the states to come into market and bid for money in competition with Congress. Congress could probably borrow money much more advantageously if they could prohibit the people from coming into the market and bidding for it in competition with them. But the advantage to be derived by Congress from such a prohibition upon the people would not authorize them to resort to it, even though the people were to offer so high a rate of interest that Congress could not borrow a dollar in competition with them. Congress must abide the competition of the people in borrowing money, be the result what it may. And they must abide the same competition in the business of carrying letters, and for the same reason, viz., because no power has been granted them to prohibit the competition. 7. The power granted to Congress on the subject of mails is both in its terms and in its nature additional to, not destructive of, the pre-existing rights of the states and the natural rights of the people. The object of the grant to Congress undoubtedly was to enable the government, in the first place, to provide for its own wants, and then to contribute incidentally, as far as it might, to the convenience of the people. But the grant contains no evidence of any intention to prohibit the states or people from using such means as they had, so far as those means might be adequate to their wants. Any other doctrine than this would imply that the people were made for the benefit of the department, and not the department for the benefit of the people. 8. In matters of government, the people are principals, and the government mere agents. And it is only as the servants and agents of the people that Congress can establish post offices and post roads. Now, it is perfectly clear that a principal, by simply authorizing an agent to carry on a particular business in his name, gives the agent no promise that he, the principal, will not also himself personally carry on business of the same kind. He plainly surrenders no right to carry on the same kind of business at pleasure. And the agent has no claim even to be consulted as to whether his principal shall set up a rival establishment to the one that is entrusted to the agent. The whole authority of the agent is limited simply to the management of the establishment confided to him. 9. It is a natural right of men to labor for each other for hire. This right is involved in the right to acquire property, a right which is guaranteed by most of the state constitutions, and not forbidden by the national constitution. No law which forbids the exercise of this right in a particular case can be constitutional, unless a clear authority be shown for it in the Constitution. No authority is shown for prohibiting the labor of carrying letters. 10. If there were any doubt as to the legal construction of the authority given to Congress, that doubt would have to be decided in favor of the largest liberty and the natural rights of individuals, because our governments, state and national, profess to be founded on the acknowledgement of men's natural rights, and to be designed to secure them, and anything ambiguous must be decided in conformity with this principle. 11. The idea that the business of carrying letters is in its nature a unit or monopoly is derived from the practice of arbitrary governments who have either made the business a monopoly in the hands of the government or granted it as a monopoly to individuals. There is nothing in the nature of the business itself, any more than in the business of transporting passengers and merchandise, that should make it a monopoly, either in the hands of the government or of individuals. Probably one great, if not the principal motive of despotic governments for maintaining this monopoly in their own hands is that in case of necessity they may use it as an engine of police, and in times of civil commotion it is used in this manner. The adoption of the same system in this country shows how blindly and thoughtlessly we follow the precedents of other countries without reference to the despotic purposes in which they had their origin. 12. An individual who carries letters cannot be said to usurp or even to exercise an authority that is granted to Congress, for Congress have authority to carry only such letters as individuals choose to offer them for carriage, whereas a private mail carries only those letters which individuals choose not to offer to the government mail. The authority of Congress over letters does not commence until the letters are actually deposited with them for conveyance, and therefore the carrying of letters that have never been deposited with them for conveyance does not conflict at all with the power of Congress to carry all the letters that they have any authority to carry. 13. It cannot be said that an individual who carries letters is doing the same thing that Congress are authorized to do. He is not doing the same thing, but only a thing of the same kind. This distinction is material and decisive. There is no objection to his doing things of the same kind as Congress, so far as he has the natural power and right to do them, unless the Constitution plainly prohibits it. 14. If Congress could forbid individuals doing a thing simply because it was similar to what the government had power to do, they might forbid his borrowing money, because to borrow money is one of the powers granted to Congress. They might also, on the same grounds, forbid parties to settle their controversies by referring them to men chosen by themselves, because government has established courts and given them authority to settle controversies, and references to other tribunals chosen by the parties is depriving this department of the government of a part of its business, and the marshals, clerks, and juries of the opportunity of earning fees. There is just as much ground in the Constitution for prohibitions upon the settlement of controversies without the aid of the government courts as there is for the prohibitions upon the transmission of letters without the aid of the government mail. 15. Suppose the Constitution had declared that Congress should have power, to establish roads and vehicles for the transportation of passengers and merchandise, instead of letters. Would such a grant have authorized Congress to forbid either the states or individuals to establish roads and vehicles in competition with those of Congress? Clearly not. Yet that case would be a perfect parallel to the case of the post office. 16. If Congress can restrain individuals from carrying letters on the ground that the revenues of the post office are diminished thereby, they may, by the same rule, prohibit any other labor that tends to diminish the revenues derived from any other particular source. They may, for instance, forbid the manufacture at home of articles that come in competition with articles imported on the ground that such home manufactures diminish the revenues from imports. 17. The extent of the power, to establish post offices and post roads, certainly cannot go beyond the meaning of the word establish. This meaning is to be determined by regarding, first, the persons using the word, and secondly, the object to which it is applied. The persons using it are, we the people, for the preamble to the Constitution declares that, we the people do ordain and establish this Constitution, The word then is used in its popular sense, in that sense in which it is ordinarily used by the mass of the people. Footnote. In the case of Ogden versus Saunders, 12 Wheaton 332, Chief Justice Marshall said that in construing the Constitution, the intention of the instrument must prevail, that this intention must be collected from its words, that its words are to be understood in that sense in which they are generally used by those for whom the instrument was intended. Mr. Webster also, in a speech made in the Senate in 1840 on the bankrupt bill, declared the same principle of interpretation to be the true one. He said, quote, "What then is the subject of bankruptcies, or in other words, what are bankruptcies? It is to be remembered that the Constitution grants the powers to Congress by particular or specific enumeration, and in making this enumeration it mentions bankruptcies as a head of legislation, or as one of the subjects over which Congress is to possess authority. Bankruptcies are the subject, and the word is most certainly to be taken in its common and popular sense, in that sense in which the people may be supposed to have understood it when they ratified the Constitution. This is the true rule of interpretation. And I may remark that it is always a little dangerous, in construing the Constitution, to search for the opinions or understanding of members of the convention in any other sources than the Constitution itself, because the Constitution owes its whole force and authority to its ratification by the people, and the people judged of it by the meaning most apparent on its face. How particular members may have understood its provisions, if it could be ascertained, would not be conclusive. The question would still be, how did the people understand it? And this can be decided only by giving their usual acceptation to all words not evidently used in a technical sense, and by inquiring, in any case, what was the interpretation or exposition presented to the people when the subject was under consideration. End footnote. That such is the true meaning of all the language of the Constitution is obvious from the consideration that otherwise we should be obliged to suppose that the people entered into a compact or agreement with each other without knowing what they themselves meant by the language they used. Besides, the word establish has no technical meaning whatever, nor had any, so far as we know, at the time the Constitution was adopted. But, secondly, the meaning of the word is to be inferred also from the nature of the object to which it is applied. Thus, we establish a principle by making it clear, proving it true, and thus fixing it in the mind. We establish a law by giving it force and authority. A man establishes his character by making it thoroughly known to the world. We establish a fact by the evidence necessary to sustain it. In these and other cases, the word establish has no exclusive meaning whatever other than this. It excludes what is necessarily inconsistent with, contradictory to, or incompatible with the establishment of the thing declared to be established. It does not exclude the establishment of any number of other things of the same kind, unless they would be necessarily inconsistent with the thing first established. Thus, the establishment of one truth does not imply the subversion or suppression of any other truth, because all truths are consistent with each other. The establishment of one man's character does not imply the destruction of any other man's character. When applied to matters of business, as for instance to the establishment of facilities for the transmission of letters, and the transmission of letters is a mere matter of business, the word establish has no meaning that implies an exclusion of competition. Thus, we speak of the establishment of a bank, a store, a hotel, a line of stages, or steamboats, or packets. But this expression does not imply at all that there are not other banks, stores, hotels, stages, steamboats, and packets established in competition with them. Neither does the establishment of certain roads as post roads imply the exclusion of all other posts than those of Congress from those roads. Congress establishes a road as a post road by simply designating it as one over which their posts shall travel. This designation clearly does not exclude the passage of any number of private posts over the same road, provided the government posts are not thereby actually obstructed or impeded in their progress. Because the establishment of any one thing implies the exclusion of nothing whatever, except what is absolutely inconsistent or incompatible with the thing established. The designation, therefore, or the establishment of a particular road as a post road, excludes nothing except obstacles to the progress of the posts over that road. The prohibition, therefore, of Congress upon the passage of other posts over the same roads traveled by their own is going beyond the simple power of establishing those roads as post roads, and beyond the simple power of establishing their own posts upon those roads. Footnote. Congress themselves have uniformly adopted the above construction as being the true meaning of the word establish when applied to post roads. For in addition to their laws establishing certain roads as post roads, they have passed other laws specifically to exclude other posts than their own. If the simple establishment of a road by Congress as a post road excluded ipso facto all other posts, all their special laws of exclusion would be unnecessary. And footnote: if Congress owned the roads over which their posts travel, they would have a right to exclude all other posts from them, not, however, by virtue of their power to establish those roads as post roads, but by virtue of their power to control the use of their own property. 18. The word establish, when applied to any particular thing, does not imply that the thing established contributes either in whole or even in part to the necessary expenses of its own maintenance. For instance, Congress have power to establish forts, arsenals, and lighthouses, but it does not follow that the forts, arsenals, and lighthouses are expected to support themselves. Congress have power to establish courts, but it does not follow that the courts are to derive their support, either directly or indirectly, from the business done in them. The same is the case with the Army, the Navy, and all the departments of government. None of these establishments are expected to derive their support from their business. Yet no compulsory process except that of "laying and collecting taxes, duties, imposts, and excises" is authorized for the support of any of them. If individuals voluntarily send letters enough by the government mail to pay the expenses of the establishment, well. If not, the establishment must go down, or be sustained like all the other departments of the government by general taxation, and not by restraints upon competition. 19. By the old Articles of Confederation, it was declared that "the United States, in Congress assembled, shall have the sole and exclusive right and power of establishing and regulating post offices from one state to another throughout all the United States." When the Constitution came to be adopted, this phraseology was altered, and the words "sole and exclusive" were omitted. This alteration of the power from a sole and exclusive one to a simple power must certainly have been intentional, and it clearly indicates that the framers of the Constitution did not intend to give to Congress under the Constitution the same exclusive power that had been possessed by the Congress of the Confederation. 20. The 10th section of the first article of the Constitution contains an enumeration of various prohibitions upon the state governments. They are prohibited from entering into any treaty, alliance, or confederation, granting letters of marque and reprisal, coining money, emitting bills of credit, making anything but gold and silver coin a tender in payment of debts, passing any bill of attainder, ex post facto law, or law impairing the obligation of contracts, laying any imposts or duties on imports or exports without the consent of Congress, except what may be necessary for executing their inspection laws, or, without the consent of Congress, laying any duty on tonnage, keeping troops or ships of war in time of peace, entering into any agreement or compact with other states or with foreign powers, or engaging in war, unless actually invaded or in such imminent danger as will not admit of delay. Among all these prohibitions, why is there none against establishing mails? The answer is obvious. The Constitution did not intend to prohibit them. 21. If the right granted to Congress to carry letters be an exclusive right, it is of necessity an exclusive right for the whole country, and not merely for such roads and offices as Congress may see fit to establish. And it would therefore be as much unconstitutional for individuals to establish mails on routes where Congress had not established any as where they had. And the consequence would be that the people would have no constitutional right to have any mails at all, except such as Congress might please to establish for them. 22. If the Constitution had intended to give to Congress the exclusive right of establishing mails, it would have required and not merely permitted Congress to establish them, so that the people might be sure of having mails. But now Congress are no more obliged to establish mails than they are to declare war. And in case they should neglect or refuse to establish them, the people could have no mails unless individuals or the states have now the right of establishing them. 23. It would have been as unconstitutional for individuals to establish mails, if Congress had neglected to do it altogether, as it is to establish them in competition with those established by Congress. For the unconstitutionality of private mails, if they are unconstitutional, consists not in the competition, but in the exercise of a right that belongs exclusively to Congress. 24. If the power granted to Congress be an exclusive right of establishing mails, then Congress have no authority even to permit individuals to establish mails on their own account, either on routes where Congress have, or on those where they have not established them. Such permission would be, so far, abdicating government in favor of such individuals. Congress have no more right to abdicate any power of this kind than to abdicate to an individual the power of making laws. 25. If the exclusive right of carrying letters has been granted to Congress, then it is unconstitutional for a person even to carry a single letter for a friend, and Congress are bound to punish such an act as an offense against the Constitution. 26. No one, I presume, has ever doubted that individuals would have a right to establish mails, but for the law of Congress forbidding them. Yet, if the Constitution had given Congress the exclusive right, private mails would have been unconstitutional, without the law. On the other hand, if the Constitution have not given Congress the exclusive right, then the law prohibiting private mails is without any constitutional authority. It is certain, therefore, that Congress, the courts, and the country have always been in an error, either as to the grant in the Constitution or the constitutionality of the law, if not as to both. 27. It may perhaps be pretended that an exclusive authority to establish mails is a prerogative of sovereignty, and therefore of the government, but this is a notion borrowed wholly from arbitrary governments. Our governments have no prerogatives of sovereignty except such as are granted to them by our constitutions, and these prerogatives are limited by the terms of the grants, without any regard to the extent of similar prerogatives under monarchical or despotic governments. 28. The only rules of interpretation, so far as I know, that have ever been laid down for determining whether a power granted to Congress is to be held by them exclusively or only concurrently with the states or people are those laid down by Hamilton and Madison, who above all other men were the fathers of the Constitution. Those rules are given by them in the Federalist, and are there treated by them as being infallible criteria by which all questions of this nature may be settled. The essays of the Federalist have ever, from the adoption of the Constitution, been considered the very highest authority on questions of constitutional law, next to the decisions of the Supreme Court of the United States. And these particular rules of interpretation are constantly cited in discussions before that tribunal, and have never, so far as I am aware, been overruled by them. Judge Story emphatically affirmed them in the case of Houston versus Moore, and said he did, quote, not know that they had ever been seriously doubted, end quote. 5 Wheaton, 48-50. The rules are these: that none of the powers granted to Congress are held by them exclusively, except in these three cases. First, where an exclusive authority is, in express terms, granted to the Union. The grant of exclusive legislation over the seat of government is an instance of this kind. Or, second, where a particular authority is granted to the Union and the exercise of a like authority is prohibited to the states. An instance of this kind is furnished in the grant to Congress of the power to coin money, and the collateral prohibition, no state shall coin money. Or third, where an authority is granted to the Union with which a similar authority in the states would be utterly incompatible. The power to pass uniform laws on the subject of bankruptcies throughout the United States is an instance of this kind. Bankrupt laws by the states would necessarily destroy the uniformity of the laws on this subject, and hence would be incompatible with the power given to Congress to establish uniformity. Tried by these rules, the power, quote, to establish post offices and post roads, end quote, has not a shadow of claim to be considered an exclusive one. The terms of the grant are not exclusive. The states or people are not prohibited by any clause from exercising a similar power. There is no incompatibility in the simultaneous exercise of such a power by each of the governments and by individuals. The rules of interpretation here stated are treated at length in the Federalist in connection with the power of taxation and the judicial power, and it is mainly, if not solely, by the application of them in construing the Constitution that the authority of Congress to prohibit all state taxes is controverted. The power of taxation, except upon exports, is granted to Congress not only in as ample terms, but in precisely the same terms as the power to establish post offices and post roads. The taxation of the states may often interfere with the taxes of Congress by rendering them less fertile or more difficult of collection, and hence it was argued by the opponents of the Constitution that Congress might assume to forbid the states to collect their taxes. But the authors of the Federalist replied that although inconveniences and interferences of policy might possibly arise from this rival taxation, yet, inasmuch as the power of taxation had not been granted to Congress in exclusive terms, and the exercise of a similar power had not been prohibited to the states, and there was no incompatibility or necessary conflict in the coexistence of such a power in each of the governments, therefore it could not be considered an exclusive one in Congress, and that Congress could therefore no more prohibit the state taxes than the states could prohibit the taxes of Congress. That each government must submit to the competition of the other as best it might. Such were the opinions of these fathers of the Constitution, and unless these principles are correct, every tax that has been levied for the support of the state governments since the adoption of the Constitution has been unconstitutional, as infringing the exclusive authority of Congress. Footnote. See the Federalist, Numbers 31, 32, 33, 34, 36, and 72. End footnote. If, then, the power of taxation is not an exclusive one, the power of establishing post offices and post roads clearly is not. For both powers are granted in precisely the same terms. The words of the grant are simply, quote, "The Congress shall have powers to lay taxes, to establish post offices," end quote, etc. Neither power is granted to Congress in exclusive terms, neither is prohibited to the states, nor is there any incompatibility in the existence of such powers in different governments at the same time. The operations of rival males do not necessarily conflict, but only compete with each other. If there be any powers whatever granted to the general government, and yet held by it concurrently either with the states or individuals, the power of establishing males is one of them, according to every principle of interpretation that has ever been laid down by any respectable authority. And those who hold that this power is not held concurrently, either with the states or individuals, or both, must hold that Congress holds no power concurrently, either with the states or individuals. Again, the 42nd number of the Federalist specially notices the post office power, and notices it in such language as to show conclusively that the authors considered it a concurrent but not an exclusive power. They say, quote, "The power of establishing post roads must, in every view, be a harmless power, and may perhaps by judicious management become productive of great public conveniency. Nothing which tends to facilitate the intercourse between the states can be deemed unworthy of the public care." End quote. And this is all they say on the subject. Now mark his language. Quote, "Nothing that tends to facilitate the intercourse between the states can be deemed unworthy of the public care. It may perhaps by judicious management become productive of great public conveniency. It must in every view be a harmless power." End quote. All this language evidently refers to the power that might, if judiciously managed, add to existing facilities, but which at any rate could not do harm by taking those facilities away. It applies therefore to a concurrent and not to an exclusive power. But mark again the strength of this expression, quote, "It must in every view," that is, in a political as well as practical one, be a harmless power." End quote. Did not Mr. Madison and Mr. Hamilton know the despotic purposes to which an exclusive power over the transmission of all commercial, social, and political intelligence might be applied? That it was capable of being made one of the most powerful engines of police? As efficient for purposes of despotism as a standing army? Certainly they did. Are they then chargeable with the effrontery of telling the people of this country that an exclusive power of this sort "must in every view be a harmless power"? No. Their characters forbid such an idea, and they had no motive for such a deception. The conclusion then is inevitable, that they did not consider it an exclusive one. Moreover, if any of the opponents of the Constitution, by whom the lurking dangers to liberty were hunted through every line and word of the instrument, had considered this power an exclusive one, they would have exposed it, and the authors of the Federalist would not then have treated it in this manner, but would have obviated the objection by showing that the power was only a concurrent one. They would have shown this by the same rules of interpretation by which the power of taxation and certain judicial powers are shown to be concurrent. But that it was merely a concurrent power seems to have been taken for granted, both by the advocates and opponents of the Constitution. But if all the preceding considerations have failed of establishing the unconstitutionality of the laws against private mails, there is still another which alone would be decisive. The first article of amendment to the Constitution declares that "Congress shall make no law abridging the freedom of speech or of the press." The freedom of speech which is here forbidden to be abridged is the natural freedom, or that freedom to which a man is entitled of natural right. And the word speech does not mean simply utterance with voice, but the communication of ideas. And the right of speech includes a right to communicate ideas in any of the various modes in which ideas may be conveyed. A man has the same natural right to speak to another on paper as viva voce, and to speak to a person 1,000 miles distant as to one who is present. Any law which compels a man to pay a certain sum of money to the government for the privilege of speaking to a distant individual, or which debars him of the right of employing such a messenger as he prefers to entrust with his communications, abridges his freedom of speech. The freedom of the press, too, which is forbidden to be abridged, is not the freedom of barely printing books and papers, for that kind of freedom alone would be of no value either to the printer or the public, but it includes the freedom of selling and circulating. And the freedom of selling and circulating involves the right of conveying them to purchasers by such messengers as one pleases to employ. If anyone is disposed to deny that manuscript correspondence comes under the denomination of speech, as that term is used in the Constitution, he must adopt the alternative of including it in the term the press, for it certainly must be embraced by one or the other. Finally, if the Constitution had intended to give Congress the exclusive right of establishing mails, it would have prescribed some rules for the government of them, so as to have secured their privacy, safety, cheapness, and the right of the people to send what information they should please through them. But the Constitution has done nothing of this kind. On the contrary, the grant is entirely unqualified, and it has made the power of Congress over such mails as they do establish entirely absolute. They may say what shall go in them and what shall not, whether they will carry sealed papers or only open ones, and even whether sealed papers, deposited in their offices, shall be sacred from the espionage of the government. Their power over their own mails is unqualified in every respect. And if the people have no power to establish mails of their own, their whole rights, both of private correspondence and of transmitting printed intelligence, are at the feet of the government. If this power, so absolute over its own mails, were also an exclusive one over all mails, it would be incomparably the most tyrannical, if not the only purely tyrannical feature of the government. The other despotic powers, such as those of unlimited taxation and unlimited military establishments, may be perverted to purposes of oppression, Yet it was necessary that the powers should be entrusted to the government for the defense of the nation. But an exclusive and unqualified power over the transmission of intelligence has no such apology. It has no adaptation to facilitate anything but the operations of tyranny. It has no aspect whatever that is favorable either to the liberty or the interests of the people. It is a power that is impossible to be exercised at all without being exerted unjustifiably. The very maintenance of the exclusive principle involves a tyranny and a destruction of individual rights that are now, as ever must be, felt through every ramification of society. The power is already exerted to the great obstruction of commercial intelligence and nearly to the destruction of all social correspondence, except among the wealthy. But that we are accustomed to such fetters, we would not submit to them for a moment. To what further extent of tyranny and mischief this power, in the future growth of the country, may be exerted, we cannot foresee. But the only absolute constitutional guarantee that the people have against all these evils and dangers is to be found in the principle that they have the right, at pleasure, to establish mails of their own. And if the people should now surrender this principle, they would thereby prove that their minds are most happily adapted to the degradation of slavery. The Postmaster General's argument. The argument of the Postmaster General is as follows. Quote, this grant of power, that is, to establish post offices and post roads, is found in the same clause, should be section, and is expressed in the same words and language of the grants of power to coin money, to regulate commerce, declare war, etc. End quote. No argument in favor of the exclusiveness of the power can be drawn from the fact here stated. Nearly all the powers granted to Congress are included in the same section, but who before ever argued that all the powers mentioned in that section were therefore exclusive? The power, quote, to lay and collect taxes, and the power to borrow money are found in the same clause, section, and expressed substantially in the same words and language of the grants to coin money, to declare war, etc. End quote. But the powers to borrow money and to lay and collect taxes are not, therefore, exclusive. The Postmaster General is certainly very unfortunate in his analogies. The exclusiveness of the powers to coin money and to declare war does not result from the terms of the grants, as his argument supposes, but from the special prohibitions in another section, to wit, quote, no state shall coin money, end quote, and, quote, no state shall declare war, end quote. But for these express prohibitions upon the states, the powers to coin money and declare war would have been concurrent powers, else why were these prohibitions inserted? There being no such prohibition in regard to establishing post offices and post roads, that power is concurrent, as those would have been but for the prohibitions. Besides, there is no analogy in principle between the exclusive power to declare war or to coin money and an exclusive power to establish post offices and post roads, because an individual has a natural power and right to establish post offices and post roads. But he has no natural power or right to declare public war. He has power only to speak and act for himself. Neither has he any natural power or right to coin money, because to coin signifies, according to lexicographers, an act of government, as distinguished from the acts of individuals. But the powers of Congress to declare war and to coin money are in reality exclusive only as against the state governments. They are not exclusive of any natural rights on the parts of individuals. The constitutional prohibition upon individuals to coin money extends no farther than to prohibitions upon counterfeiting the securities and current coin of the United States. Provided individuals do not counterfeit or imitate the securities or current coin of the United States, they have a perfect right, and Congress have no power to prohibit them, to weigh and assay pieces of gold and silver, mark upon them their weight and fineness, and sell them for whatever they will bring, in competition with the coin of the United States. It was stated in Congress a few years since by Mr. Rainier, I think of North Carolina, that in some parts of the gold region of that state, a considerable portion of their local currency consisted of pieces of gold, weighed, assayed, and marked by an individual in whom the public had confidence. And this practice was as unquestionably legal as the sale of gold in any other way. It was no infringement of the rights of Congress. The same is true in regard to war. Individuals have no natural power to declare public war, but the natural right of individuals to make private war is secured to them by that clause of the Constitution that secures to them the right to keep and bear arms. It is true, the natural right of individuals to make war extends no farther than is necessary for the purposes of defense. Their natural power, however, goes beyond this limit, and if an individual were to exercise his natural power for making war for other purposes than defense, he would be punished only as a murderer or a pirate, and solely on the ground of having transcended his natural right, certainly not on the ground of his having infringed the exclusive power of Congress. The power of Congress to regulate commerce, which is quoted by the Postmaster General as a parallel case to the post office power, is held to be exclusive solely on the ground of the unity of the subject. In the case of Gibbons versus Ogden, 9 Wheaton, Mr. Webster's argument in favor of the exclusive power of Congress over commerce was this, that commerce was a unit, and that regulations by the states, operating upon the identical thing that was under the regulation of Congress, would necessarily conflict with the regulations of Congress, because, he said, the regulations of Congress may consist as much in leaving some parts free as in regulating others, and the court concurred in this opinion. That commerce is a unit is obvious. There is but one commerce with foreign nations, into however many parts and varieties it may be subdivided. Commerce is a word that has no plural. It embraces every variety, part, and parcel of all the different kinds of commerce that are carried on by individuals. But there is no unity in the term post offices or post roads any more than there is in the term stagecoaches or steamboats. Suppose the Constitution had said that, quote, Congress shall have the power to establish stagecoaches and steamboats, end quote. Would anyone have imagined that Congress had thereby acquired the exclusive right of establishing stagecoaches and steamboats? But there is a lack of analogy in another particular between the powers to regulate commerce and the power to establish post offices and post roads. The power to regulate and the power to establish are in their nature very different powers. No power is granted to Congress to carry on or establish commerce on their own account, but only to regulate that which is carried on by others. Their post office power is directly the reverse of this. It is the power to establish post offices of their own, but not to regulate the offices or business of others. But the Postmaster General says further that the grant of power to establish post offices and post roads is ample, full, and consequently exclusive. According to this reasoning, the power of Congress to borrow money is exclusive, for it is both ample and full, precisely as ample and full as the power to establish post offices and post roads. The power of taxation, except upon exports, is also ample, full, and according to the argument of the Postmaster General, consequently exclusive. Such are the absurdities into which men are obliged to run in order to find apologies for claiming that a simple power to establish post offices and post roads is an exclusive one. But the Postmaster General says further, quote, if a doubt could exist as to the exclusiveness of this grant, that doubt must vanish upon the reference to the 10th article of the amendments to the Constitution, which declares, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. The power to establish post offices and post roads is plainly and distinctly delegated to the United States. It is therefore not a power reserved to the states respectively or to the people. This implication is as unfounded as it is far-fetched and unnatural. The language quoted by the Postmaster General is not contained in the original Constitution, but constitutes an amendment that was subsequently adopted. It is one of the 10 amendments that were adopted soon after the original Constitution had gone into operation. These amendments were all adopted for the avowed purpose of quieting the fears of those who thought that too great powers had already been given to the government. Not one of the whole 10 purports to grant any new power to Congress or to enlarge any of the powers that had been previously granted. On the contrary, every one of them, without an exception, purports either to prohibit Congress from stretching their powers beyond the terms of the original grants, or to secure some principle of civil liberty against all pretenses of power on the part of Congress. And the very amendment quoted by the Postmaster General was obviously designed, and designed solely, as a prohibition upon the usurpation of any power not previously granted. Yet now the Postmaster General, by a backhanded and unnatural implication, would draw from a simple amendatory prohibition of this kind a warrant for enlarging all the original powers and making those exclusive and despotic which were before harmless and concurrent. But again, the language of this amendment is simply that, "the powers not delegated to the United States by the Constitution (as distinct from the amendments), nor prohibited by it to the States, are reserved to the States respectively, or to the people." Now the inference of the Postmaster General from this language might, safely to the argument, be admitted to be correct, if it were also considered what kind of a power, on the subject of post offices and post roads, had really been delegated to the United States by the Constitution. What was that power? It was, as has been shown, merely a power concurrent with that of the States and the people to establish post offices and post roads. Only a concurrent power then having been delegated, and a like power not having been prohibited to the States or people, it necessarily follows from the terms of the amendment itself that a concurrent power to establish them is reserved to the States respectively, or to the people, or to both. But the Postmaster General reasons as if none but exclusive powers had been either delegated or reserved. His whole argument hangs upon this idea. He cannot conceive of concurrent powers. It is probably a mystery to him how even two individuals can have concurrent rights to establish business of any kind in competition with each other. If the implications of the Postmaster General were correct, the powers of Congress to lay and collect taxes and to borrow money are now exclusive powers, for they are plainly and distinctly delegated to the United States, and therefore, according to his argument, are not reserved to the States respectively or to the people. Nearly all the plausibility of the Postmaster General's argument, if it have any plausibility, is derived from the unauthorized use of the article "the." He says "the power," as if there were or could be but one power of the kind in the country, is plainly and distinctly delegated to the United States, and then infers that it cannot, of course, be reserved to the States or people, because that would involve an impossibility. Now, it happens that the power delegated to the United States on this subject is not described in the Constitution as "the power," meaning thereby a sole power, but it is described simply as "power." The Constitution does not say that Congress shall have "the power," but only that they shall have power, that is, a power, or, more properly still, sufficient power to establish post offices and post roads. He might with the same propriety have said that "the power," instead of "a power" to borrow money, had been delegated to the United States, and that therefore no similar power could be reserved to the States or people, as if there were or could be but one power in the whole country constitutionally capable of borrowing money. Or he might with the same propriety have said that "the power" of taxation, instead of "a power" of taxation, had been delegated to Congress, and that therefore no similar power had been reserved to the States or people. When, in common parlance, we use the article "the" in connection with a power granted to Congress, as for instance in the expression "the power of Congress to borrow money," or "the power of Congress to lay and collect taxes," or "the power of Congress to establish post offices and post roads," we do not use it to designate certain sole powers or units, but to designate the powers existing in Congress, as distinguished from similar or other powers existing in the states or individuals. But the Postmaster General has not only substituted the language of common parlance for the language of the Constitution, but has also given to it a different meaning from what, even in common parlance, is attached to it. The whole argument of the Postmaster General, as has already been said, rests upon the assumption that there is or can be but one power of any one kind in the whole country, and that if this one power be granted to Congress, it cannot, of course, remain with the states or people. If this doctrine is correct, all the powers granted to Congress would necessarily have been exclusive, without any express prohibitions either upon the states or individuals, and consequently all the express prohibitions in the Constitution would have been mere surplusage. But there is still another oversight in the argument of the Postmaster General. A simple power to establish post offices and post roads, and the power of prohibiting similar establishments by others, are in their nature distinct powers. The former alone having been delegated to Congress, the latter necessarily remains, and is declared, by the amendment cited, to remain with the states or the people. Neither the states nor the people have seen fit to exercise this prohibitory power that is thus reserved to them, and they probably never will. They cannot exercise it without abridging the freedom of speech and the press, and infringing a fundamental principle of civil liberty. Still further, no implication, natural or unnatural, logical or illogical, necessary or unnecessary, can prevail against an express provision. The provision is express, that Congress shall make no law, post office law or any other, abridging the freedom of speech or of the press. The power of Congress, then, on this subject is just what it would have been, and only what it would have been, if the two clauses had stood in connection in this wise. Congress shall have power to establish post offices and post roads, but shall make no law abridging freedom of speech or of the press. Expediency. The whole argument of expediency in favor of maintaining an exclusive power in the government over mails may be summed up in this. It enables the government to throw upon those who live in the populous portions of the country and who have been at the expense of constructing extraordinary facilities for transportation, the burden of all the government postage, and the portion of the expense of carrying mails to those who have voluntarily gone beyond the reach of those facilities, and who have no more claim that their letters shall be carried to them at the expense of other people than that their food and clothing shall be. Palpably unjust and tyrannical as are these objects of the law, they are in reality the only arguments that can be invented in support of it. The policy of the law is on a par with its morality. A law for defraying expenses of government by a tax upon and consequently by obstructing the dissemination of commercial, social, and political information probably combines as many of the elements of barbarism as any law that perverted ingenuity or political depravity has ever devised. The extortion also of money from individuals in the populous portions of the country in order to support the present expensive mode of carrying mails to the less populous portions is in one respect like filching from one his good name. It is robbing one without enriching another. If the business were open to free competition, there probably is not a man who lives fairly within the limits of civilization that would not receive his letters at less cost than he now pays. And if any man has chosen to go beyond those limits, he certainly has no right to claim that we who remain behind shall be taxed to carry civilization to him. If, however, the government chooses to pursue such men with its generosity, it should at least have the decency to be generous with means honestly obtained, instead of obtaining them by so unequal and mischievous a tax as upon the diffusion of knowledge. The progress of the whole civilized portion of the country certainly ought not to be retarded in order that the government may show its partiality for those few individuals who, by going beyond the limits of civilization, give strong evidence that they do not appreciate its benefits. But in reality, the inmates of the farthest cabins on our frontier are interested in free competition as a constitutional principle, for even if they should not at once, under that system, although they probably would soon, have as good facilities as they now enjoy, it will yet be but a few years before these same cabins will be in the midst of a numerous population, all of whom will be benefited by the free principle. The inhabitants of the frontier are also, for their posterity if not for themselves, equally interested with other portions of the country in maintaining the freedom of speech and the press, and the free principles generally of our Constitution. The present expensive, dilatory, and exclusive system of mails is a great national nuisance, commercially, morally, and socially. Its immense patronage and power, used as they always will be, corruptly, make it also a very great political evil. The moral, social, and political evils of the system are of a nature not to be estimated in money. The commercial ones, although incapable of any accurate estimate, are yet of a nature more susceptible of calculation. Let us look at them for a moment. The importance of dispatch in commercial correspondence may be in some measure conceived of when it is considered that every day's and hour's delay in the sale and transmission of merchandise, whose sale and transmission wait on correspondence, involves a loss, during the time of such delay, of the interest, insurance, and storage of such merchandise, and also a lapse in part of the season when particular kinds of merchandise are most valuable to consumers, and of course command the best prices in the hands of the merchant. Delays in business correspondence of all other kinds, as well as that strictly commercial, are also attended with losses more or less important. Suppose now that on an average throughout the whole country, 1/5 of the time that is now occupied in the transmission of commercial and other letters should be saved by opening the business to competition, what would be the aggregate saving in dollars and cents to the whole country? Is not $12,000 a day a moderate estimate? Undoubtedly, I think the real savings would be very much, probably several times greater than this sum. But I have mentioned this amount because it is, in round numbers, the actual expenses of the present establishment. If, then, this sum only could be saved by opening the business to competition, the country as a whole could actually afford, as a matter of mere dollars and cents, to let the present establishment retire upon an annual pension equal in amount to the whole of its present receipt, as a compensation for its simply getting out of the way of private enterprise. In other words, the country could afford to support the establishment in idleness for the sake of getting rid of its services. We should also gain in the bargain the social benefits of cheap postage and the political benefits of a very material purification of the government. The question then is, would 1/5 of the time now occupied in the transmission of letters be saved by a system of free competition? There can be but one answer to this question. That amount of saving might not be accomplished at the outset, but it speedily would be. Universal experience attests that government establishments cannot keep pace with private enterprise in matters of business, and the transmission of letters is a mere matter of business. Private enterprise has always the most active physical powers and the most ingenious mental ones. It is constantly increasing its speed and simplifying and cheapening its operations. But government functionaries, secure in the enjoyment of warm nests, large salaries, official honors and power, and presidential smiles, all of which they are sure of so long as they are the partisans of the president, feel few quickening impulses to labor, and are altogether too independent and dignified personages to move at the speed that commercial interests require. They take office to enjoy its honors and emoluments, not to get their living by the sweat of their brows. They are too well satisfied with their own conditions to trouble their heads with plans for improving the accustomed modes of doing the business of their departments, too wise in their own estimation, or too jealous of their assumed superiority, to adopt the suggestions of others, too cowardly to innovate, and too selfish to part with any of their power or to reform the abuses on which they thrive. The consequence is, as we now see, that when a cumbrous, clumsy, expensive, and dilatory government system is once established, it is nearly impossible to modify or materially improve it. Opening the business to rivalry and free competition is the only way to get rid of the nuisance. But even if the government were to continue its operations, competition is still an important principle to its utility, for it is the only principle that can always compel it to adapt its speed and prices to the convenience of the public. End of the Unconstitutionality of the Laws of Congress Prohibiting Private Mail by Lysander Spooner.